Picture a quiet afternoon at UCLA. Students are walking past the brick arches of Royce Hall, getting ready for the fall semester.
Right.
On the surface, it's the picture of institutional stability. I mean, a system that has operated this way for decades.
For sure. Business as usual.
Exactly. For years, the consensus in California, and frankly in half the United States, was that if you grew up here and graduated from a local high school, you paid the local tuition rate.
It was a settled norm.
A settled, almost boring bureaucratic norm. But then the atmosphere surrounding that stability shifted dramatically. It wasn't a gradual policy debate. It was a sudden multi-front legal action.
A blitzkrieg, really.
Yeah, that's the word. In the span of just 7 days, the federal government hit the state with a series of high-stakes legal challenges.
And the rationale just took this incredibly sharp, aggressive turn.
Right. Suddenly, the Attorney General wasn't just arguing about immigration enforcement at the border, but claiming that by helping these long-term residents, the state was actively discriminating against U.S. citizens.
Which is a complete reframing of the issue.
It's a huge reframing. And this aggressive strategy creates a jarring disconnect. How is a massive state institution supposed to conduct business as usual when a decades-old status quo faces a whole-of-government offensive?
And it's targeting everything.
Everything, from the tuition check students' right to the very foundation of institutional independence.
And that juxtaposition you just described is really the central theme of this deep dive.
Okay.
We are examining an unprecedented multi-front offensive targeting the University of California system and, its broader state policies.
The two fronts, really.
Exactly. What we have here are two very distinct, yet what seems to be a demonstrably coordinated set of legal threats. The first is focused squarely on immigration status and tuition policy.
Challenging the state's right to set its own policy.
Right. Challenging state sovereignty and the legal interpretation of which benefits a state can offer its own residents. But the second one, and this is perhaps the more structurally damaging.
The big one.
The big one. It's this systematic task force policy campaign. And this campaign is aimed at the UC system, using severe financial coercion.
A financial weapon.
A weapon, yeah. Under the pretext of civil rights enforcement, to impose a specific, sweeping ideological agenda on research, on governance, and on the fundamental operation of campus life itself.
Okay, so let's unpack this operation. Our core question today really boils down to institutional navigation, specifically for you, the listener, who needs to understand the mechanics of this conflict.
Right.
How is a massive state institution like the University of California system, which, let's be clear, relies on billions in federal research funding, how is it supposed to operate when federal demands clash directly with decades of established state policies?
Policies on everything.
On tuition, on academic freedom, civil rights. We need to lay out the immediate, tangible costs to research, to students, and to academic independence when the federal government decides to play legal hardball. So let's start with that first front you mentioned, the immigration lawsuit targeting state tuition laws. This whole thing is rooted in a decades-old norm, right? It predates a lot of the current political flashpoints.
Oh, absolutely. It's really just about residency and tuition rates.
Simple as that.
At its core, yes. This isn't a new fight, but the intensity of the federal push is new. For decades, you've had something like half the country.
Wow, half. I didn't realize it was that widespread.
Yeah, about half, including major states like California, of course, but also New York, Washington, and many in the South. Texas had a similar law for a very long time.
Wow.
And these policies allowed long-term residents who graduated from local high schools to pay the significantly lower in-state tuition rate, regardless of their legal immigration status.
And the philosophy behind that. What was the thinking?
It was essentially an investment model. I mean, look at it this way. The state had already paid for 12 years of K-12 education for these students.
Right, they're products of the state system.
Exactly. So denying them affordable college simply wasted that investment and, suppressed their potential economic contribution down the line.
So in California, this is all crystallized in what's called the California Dream Act. Can you break down what that act actually does for these students?
Sure. The California Dream Act is multifaceted, but it does two crucial things. First, and most obviously, it grants them that in-state tuition rate.
And the difference there is huge.
Oh, it's massive. We're talking tens of thousands of dollars per year. The difference between the in-state and out-of-state tuition is, for many, a completely prohibitive barrier.
So it's the difference between going to college or not.
For most of these low-income families, absolutely. But the second part is just as vital. The act also allows these students, provided they meet certain requirements.
Like,
Things like attending a California high school for 3 or more years. If they meet that, they can apply for state-funded financial aid.
so not federal aid, but state grants.
Correct. And that financial aid component is vital for access and, just as importantly, for success once they're in. This policy framework essentially treats these students as what they are: long-term state residents who have demonstrated a commitment to the community.
Okay, so given that framework of rewarding integration and investment,
Yeah.
how does the federal government rationalize suing the state and claiming that this practice is discriminatory? What's the explicit legal interpretation they're using?
So the federal legal rationale hinges on a specific federal statute. It's 8 U.S.C. Section 1621.
Okay.
This statute was passed back in 1996, and it generally prohibits states from granting state or local public benefits based on residence to undocumented immigrants.
Right.
Unless, and this is the key part, unless the state also makes those benefits available to all U.S. citizens, regardless of their residence, by enacting a specific state law to that effect.
So the Attorney General's argument is that California is giving something to non-citizens. It isn't giving to all citizens everywhere.
Exactly. The argument is explicit. California is illegally discriminating against American students and families by offering exclusive tuition benefits for non-citizens. The key move here is that the federal government is trying to define the in-state tuition rate as an exclusive benefit.
Wait, I need to pause on that. That seems counterintuitive. If the tuition rate is based on residency, meaning any U.S. citizen who is also a California resident and a California high school graduate gets the exact same rate, how can they logically claim the benefit is exclusive to non-citizens?
That is precisely where the legal battle lies. That's the heart of the whole dispute.
It seems like a contradiction.
It is. And the state's counterargument, which has been the successful stance in several court challenges across the country, is rooted in what's called the same circumstances standard.
Okay, what's that?
Supporters of the California law argue that they do not violate federal law because they provide the same rates to U.S. citizens who are in the same circumstances.
Meaning they're also California residents and high school grads.
Correct. They argue that the federal government is misinterpreting Section 1621. They claim the federal position implies that a state must grant benefits to citizens living outside the state, say in Ohio or Florida, just because it granted them to non-citizens living inside California.
Which would kind of defeat the whole purpose of in-state tuition.
It would completely dismantle the concept. The state contends the federal statute allows benefits based on residency as long as citizens who share that residency criteria are treated equally.
Now, this issue has clearly been a target, and you said California isn't operating in a vacuum here. Have other states faced this kind of legal pressure and, well, buckled?
Absolutely. When you look at the landscape, you see a clear, coordinated effort targeting these state laws.
So it's not just a one-off lawsuit.
Not at all. Lawsuits have been filed against similar policies in Illinois, Oklahoma, Minnesota, Kentucky, Texas. The list goes on. And in several high-profile cases, the federal pressure resulted in a policy reversal.
Like where?
Texas is a big example. It ended its long-standing in-state tuition law after facing these intense legal challenges. And Florida scrapped its law just last year.
So the threat of a lawsuit is enough sometimes.
It is. This demonstrates the immediate chilling effect that initiating these high-stakes federal lawsuits can have on state legislatures and university systems, even if the state believes its legal defense is strong. The fight itself is costly and politically damaging.
And we can't talk about California without discussing the sheer scale of this. What are the socioeconomic stakes for the students who are caught in the middle of this legal fight?
The human stakes are just enormous, primarily because of the sheer size of the UC and CSU systems.
Give us the numbers.
The California State University System, the CSU, serves over 460,000 students. The UC system serves about 300,000.
So 750,000 students, roughly.
Roughly. And for the CSU system, more than a quarter of all undergraduates are first-generation college students. If these students lose access to in-state tuition, you're not just tweaking a policy, you are effectively telling them they lose the ability to go to college, period.
And many of them have never known another home.
That's the other crucial human element. Many of the affected students were brought to the U.S. as small children. They are completely integrated into their communities. They often speak English as their primary language and have no memory of living anywhere but California.
So it's really an issue of economic mobility then, far beyond just immigration policy.
It is entirely about economic mobility. By denying them access to affordable public higher education, the state risks creating a permanent underclass.
An underclass that can't contribute fully.
Exactly. They can't contribute fully to the tax base or the skilled labor market. Their success directly correlates with the state's long-term economic health. If the courts rule against the state, the effect will be immediate. It would render the California Dream Act essentially meaningless for college access and would force potentially hundreds of thousands of established residents out of the higher education system.
That's the magnitude of the conflict on just the tuition front.
That's that one front, yes.
Okay, so that's one coordinated challenge targeting state tuition sovereignty. Let's pivot now to the second front, which is, as you said, arguably more systemic and financially devastating. This task force policy being executed against the University of California system.
Right.
This is where the federal government appears to be weaponizing its financial power to enforce ideological change.
This is where the conflict escalates dramatically. It moves from a state policy debate to, as you said, systemic financial coercion. And to really grasp the severity, you have to understand the scale of UC.
It's massive.
It's a behemoth. Its operating revenue for the current fiscal year, 2024-2025, is approximately $53 billion.
$53 billion.
But here's the dependency. The entire UC system receives over $17 billion annually in federal support.
$17 billion, and where does that money go?
It's spread across key areas. A huge chunk is research funds, of course, but also student financial aid and massive amounts tied to federal health programs like Medicare and Medicaid, which flow through the UC health facilities.
That $17 billion figure, I mean, that makes the university system incredibly vulnerable. How concentrated is that federal funding in the research core of the university?
It is the foundation of their academic identity. Federal funds constitute a staggering 52% of all UC research expenditures.
52%, so over half of all research.
Over half, which means that if the federal tap is shut off, half of the active scientific and academic work across the 10-campus system, including all the medical schools, all the labs, it instantly ceases. This level of dependency is the precise lever that the task force policy is designed to pull.
And the sequence that triggered this specific action against UCLA began with a civil rights investigation following the spring 2024 protest encampment. Is that correct?
That's the essential context, yes. The Department of Justice opened a civil rights investigation into UCLA, focusing on alleged anti-Semitism following the protest encampment. The DOJ then issued a notice of findings alleging discrimination.
Which is a standard part of the process.
It can be, but what happened next was completely unprecedented.
Okay.
It was these immediate, abrupt financial sanctions that seemed wholly disproportionate to the stated violation. The very next day after the notice, key federal funding agencies, we're talking the National Institutes of Health, the NIH.
The big one.
The big one. The National Science Foundation, NSF, and the Department of Energy, DOE, they summarily cut off a combined $584 million in research funds specifically from UCLA.
Summarily cut off, that phrase. It highlights a crucial procedural detail. Because when federal agencies like the NIH terminate funding over alleged civil rights violations, like Title VI or Title IX, they are typically bound by highly detailed and mandatory procedural requirements, right, to ensure fairness.
They are, and the allegation is that these agencies, which the lawsuit refers to as the terminating defendants, knowingly bypass those requirements entirely.
So what are those requirements? What did they skip?
Title VI and Title IX enforcement procedures are supposed to follow a very strict sequence. First, the agency has to attempt to secure voluntary compliance from the institution.
So work with them first.
Right. Talk to them, try to fix it. Second, if that fails, they must make an express finding on the record after opportunity for hearing.
A hearing. Due process.
Due process. Third, they have to file a full written report detailing the specific violation to Congress. And finally, they must wait 30 days after reporting to Congress before terminating any funds.
So these requirements exist specifically to make sure that the ultimate remedy, cutting off federal funds, isn't used as an instant punitive weapon. It's a last resort.
Exactly. It's designed to transform enforcement from political coercion into regulatory oversight. It's a system of checks and balances.
And they skipped all of it.
The allegation is that they skipped every single one of those steps. No hearing, no finding on the record, no voluntary compliance attempt. They turned the procedural mandate into a weapon, instantly impacting roughly 300 active research awards without any due process.
So the financial hammer fell first, and then came the demands, which this is the part that truly exposes the ideological reach of this policy. The UC system received a letter demanding a massive payment one that far exceeded the funds they had already suspended.
That letter, the August 8 demand letter, was astounding. It demanded that UC pay $1.2 billion as part of a settlement.
$1 billion.
$1.2 billion, just to restore the already lost $584 million.
That math doesn't even make sense.
It's not supposed to. That $1.2 billion represents over 10% of UCLA's total annual budget. It's an amount that is effectively impossible to pay.
A poison pill.
And moreover, the letter was coercive by definition because it explicitly reserved the right for the federal government to assert new claims against the university system at any point in the future. So it's a ransom demand that guarantees no future security.
And what makes this campaign so transparently ideological is the list of sweeping non-monetary demands that were included in that August 8 letter. These demands went far beyond anything to do with civil rights compliance related to campus protests.
Oh, way beyond.
They aim to dictate institutional policy on entirely unrelated issues. Let's go through the breadth of these demands because it's pretty stunning.
They represent a profound attempt to commandeer institutional policy from the federal level.
Okay, starting with speech and assembly. What did the federal government demand regarding student protest activities?
They demanded sweeping restrictions on expressive activities. UCLA was required to prohibit demonstrations and expressive activities in specified indoor or high-traffic outdoor locations.
So creating zones where speech is forbidden.
Exactly. They also required the university to prohibit overnight demonstrations anywhere on campus and to ban the use of masks or face coverings used for anonymous protest.
The mask ban is interesting.
It is. It's a tactic aimed to fundamentally limit the mechanism of dissent on campus, effectively shrinking the public forum available to students and making them more identifiable and thus more vulnerable.
Okay, next. The demands concerning social and gender definitions are particularly striking. They directly challenge UC policies on healthcare and identity.
This is where the ideological nature is most apparent and, frankly, most shocking. The letter demanded that UCLA ban gender-affirming care for transgender minors at its extensive medical centers.
So directly interfering with the medical judgment of its own doctors.
Directly interfering with professional medical ethics and standards of care, but it went further. It required the university to prohibit gender-appropriate locker rooms, restrooms, and dorm rooms for transgender students.
Wow.
And to formally declare as an institution that the university does not recognize transgender people's gender identities.
A forced declaration of belief.
Yes. And you have to ask yourself, what do these demands have to do with the initial Title VI investigation into anti-Semitism? The answer is nothing, yet they were leveraged as a condition for restoring research funding.
And of course, the political focus on diversity, equity, and inclusion, or DEI programs, was also a core part of the demanded changes.
Absolutely. The demands sought to prohibit all DEI programs, claiming they constituted discrimination.
Under what rationale?
The claim was that they violate Title VI ban on race-based discrimination. The demands included a ban on indirect methods or criteria that serve as a substitute for race-conscious hiring.
Which is very broad language.
Extremely broad. Furthermore, they demanded the elimination of race or ethnicity-based scholarships and the banning of any use of racial identity references in personal statements for employment. A total dismantling of those programs.
And finally, there was a provision that targeted international students specifically, linking admissions criteria to their political viewpoints.
Yes, this was another unprecedented step. The university was required to share international students' disciplinary records with the federal government.
Okay.
And to implement policies designed to avoid recruiting or admitting international students who are likely to engage in anti-Western, anti-American, or anti-Semitic disruptions or harassment.
Likely to engage. That sounds like pre-crime. How do you even assess that?
You can't, not without an unprecedented level of surveillance and ideological screening. It requires the university to police the political thoughts of potential students rather than their academic merit.
And all of this culminates in a demand for a profound surrender of institutional autonomy.
That's the end game, the ultimate control mechanism. The appointment of an external resolution monitor with significant authority over campus affairs.
Monitor.
A monitor who would report directly to the federal government, effectively creating a federal czar over internal university operations and governance.
Bypassing the UC regents, the president?
Everyone.
Everyone.
When you put all these demands together, it becomes crystal clear that the campaign's objective was not mere civil rights compliance, but a total ideological takeover. And this systemic use of financial penalties, combined with these sweeping ideological demands, is what defines the task force policy playbook.
And this isn't just a theory, right? This playbook has been deployed successfully against other top-tier institutions already.
That's why UC is so threatened and why they're fighting back so hard. Legal documents confirm that this task force policy has already been executed against major schools. We're talking Columbia, Brown, Penn, Harvard.
The Ivy League.
Right. And the administration officials involved have been explicitly clear about the intent behind this financial pressure. Official threats were quoted in documents saying, and this is a direct quote, "We're going to bankrupt these universities. We're going to take away every single federal dollar."
They're not hiding the ball. The threat against UC was similarly explicit about using financial levers to impose change.
Precisely. The threat cited was, quote, "Expect massive lawsuits against UC system. There's numerous ways to hurt them financially." The stated goal, as confirmed by those implementing the policy, is to reshape America's universities, which they often characterize as overly focused on left or woke ideology, by cutting off the financial lifeblood necessary for their operations.
So let's move now to the immediate tangible cost of that $584 million cut. This wasn't just a line item in a budget. It instantly impacted active, multi-year scientific endeavor.
The destruction was instantaneous and pervasive. When grant money is summarily suspended, there's no smooth wind down.
The checks just stopped coming.
The checks stop, and experiments are interrupted and delayed. Specialized lab personnel are laid off because their salaries depend on those specific grants. The entire scope of research is severely curtailed.
Is there a specific example of this happening?
Yes, there's a poignant, concrete example of NIH-funded cancer research on cancer progression that was abruptly halted.
Cancer research.
Yes. The graduate student researcher involved had to stop the detailed mechanistic studies he had planned. And his quote on this was, "Importantly, knowledge that could improve human health has been lost." This isn't just a theory. It's an immediate setback for global public health efforts.
But the long-term systemic damage is arguably the greater concern. This affects the entire scientific infrastructure, not just one lab.
It creates widespread, irreparable structural harm to the scientific enterprise. I mean, think about the wasted taxpayer-funded resources. These are multi-year grants where expensive equipment has been purchased, data has been collected, thousands of hours have been invested, all of it now stranded midstream. Then there is the harm to long-standing partner organizations, other universities, private companies, nonprofits that rely on UC's research expertise and data. The ripple effect is huge.
And what about the talent pipeline? When funding vanishes like this, it must affect the next generation of researchers.
That is perhaps the most significant long-term consequence. Professional opportunities for postdoctoral students, graduate students, and trainees who are the next generation of principal investigators, they're compromised.
Their careers are put on hold.
Stalled, or even destroyed. It could force them to leave the field entirely. If you cannot guarantee stable funding for critical long-term research like climate modeling or disease mechanisms, you drive talent away from public institutions. You weaken the nation's overall scientific output for a generation.
Beyond the scientific and financial loss, we have to consider the constitutional injury, the chilling effect on academic inquiry and free speech across the entire UC system.
And that chilling effect is palpable. It's not theoretical.
What's that look like in practice?
Faculty across various campuses reported to observers that they were actively changing their syllabi. Already. They were avoiding sensitive discussion topics, whether it's the Israel-Palestine conflict, which triggered the initial investigation, or even discussions on transgender rights, because they understand those topics are deemed politically disfavored by the federal administration.
It's self-censorship.
It's system-wide self-censorship, driven by the fear that discussing certain material or holding certain viewpoints could jeopardize billions in funding for their entire university. It impacts faculty, students, and staff alike.
And the institutions themselves have already begun to show signs of capitulation, right? Undermining the rights of their own members in an attempt to appease the federal government.
Yes. The UC system, in an effort to show signs it was listening to the Trump administration, ended the practice of using domesticity statements in faculty hiring,
which were designed to attract candidates committed to diverse learning environments.
Correct. But perhaps more alarming was the policy change at UCLA medical facilities. They expanded federal law enforcement, including ICE, access to those facilities.
And that decision has specific, non-academic consequences for the community they're supposed to serve.
It does. It subjects workers and patients, including undocumented individuals who rely on UCLA Health, to intimidating confrontations that could lead to arrest or deportation. Crucially, this action seriously undermines patient trust.
Of course.
If a significant portion of your community fears seeking necessary medical care because federal enforcement agents have easy access to the hospital, the university is actively undermining its own public health mission, not to mention state-level protections for those residents.
Let's consider the final point on this irreparable harm.
Yeah.
What happens if the UC leadership just bows to the specific ideological demands in that August 8 letter to get the funding back?
If UC capitulates, the harm shifts from monetary loss and scientific destruction to actively trampling the rights and safety of specific members of the campus community.
So a different kind of harm.
A direct human harm. If the UC bans gender-affirming care, healthcare providers would be forced to violate their professional judgment, potentially causing severe harm to patients. If the UC prohibits gender-appropriate facilities for transgender students, those individuals are forcibly relocated to spaces that increase their risk of harassment or violence.
They'd be violating their own principles and state laws.
Exactly. Accepting these terms would violate state anti-discrimination laws and fundamentally undermine the university's commitment to protecting its students and faculty. The choice presented by the federal government is truly a choice between two forms of irreparable damage.
So given the scale of this coordinated coercive campaign, the legal counterattack that's been brought by faculty associations and researchers has to address these constitutional questions head on. Let's analyze the legal claims challenging the very legality of this task force policy.
The legal claims are robust and complex, and they're rooted in fundamental constitutional principles. The first and most central argument is that the federal actions constitute unconstitutional government coercion by discriminating based on viewpoint.
The First Amendment.
The core First Amendment violation. The government is barred from doing indirectly through financial threats what it cannot do directly, which is punishing or suppressing viewpoints it labels as left or woke.
So courts use a set of factors, right? 4 factors to determine if government action crosses the line from permissible persuasion into unconstitutional coercion. Were those factors met here?
All 4 factors appear to be met decisively in this case. Number 1 is word choice and tone.
The threats.
The explicit threats. We're going to bankrupt these universities and take away every single federal dollar. That is far beyond mere regulatory advisement.
Okay, what's number 2?
Number 2 is regulatory authority. The fact that the DOJ and the funding agencies hold direct authority over Title VI and IX enforcement makes the threat incredibly credible. They hold the purse strings. Recipient perception. Statements from UC President Milliken confirmed the threat was perceived as coercive. He labeled the cuts as one of the gravest threats to the UC in our 157-year history. They clearly saw it as a threat.
And the last one is the most powerful, I assume.
It is. Number 4 is reference to adverse consequences. And in this case, the federal government didn't just refer to adverse consequences. They already imposed them by summarily suspending the $584 million.
They showed they were willing to do it.
Exactly. This is proof that the threat was not idle, and it establishes a clear pattern of retaliation against disfavored academic or political speech.
Okay, let's move to the second major constitutional challenge, the spending clause and 10th Amendment arguments. This is about federalism and state sovereignty and requires us to understand how federal funding conditions are supposed to work.
This is critical. The federal government derives its power to attach conditions to funds from the spending clause of Article 1.
But that power isn't unlimited.
It is not unlimited. It is governed by what's known as the unconstitutional conditions doctrine. For Congress to attach a condition to federal money, say research funds, that condition has to be reasonably related to the purpose of that funding.
So to put it simply, the government can't use money for cancer research to tell a university how to run its dorms.
That is a perfect way to put it. The argument here is that the federal government is leveraging funding intended for scientific research or student aid to regulate completely unrelated aspects of campus life. Gender identity definitions, speech rules, protest zones, medical center policies. These regulations are far beyond the scope of Title VI or IX enforcement and exceed Congress's authority.
And how does this connect to the 10th Amendment argument, the one that says the federal government can't just command state entities to do its bidding?
The 10th Amendment states that the federal government cannot compel states to implement federal regulatory programs. The legal theory here asserts that coercing a state university, which is a state entity, to implement federal policy is an illegal intrusion into state sovereignty.
This sounds strikingly similar to a famous Supreme Court case regarding the Affordable Care Act. Can you elaborate on the parallel between this UC financial threat and that precedent? I think it was called economic tribunal.
That's the one. The case is NFIB v. Sebelius, and it is the key precedent here. In that ruling, the Supreme Court held that the federal government acted unconstitutionally when it threatened to strip all existing Medicaid funds from states that refused to expand Medicaid under the ACA.
So it was an all-or-nothing threat.
It was, and the court found that because states were already so reliant on Medicaid funds, the threat was not merely persuasive, but constituted economic dragooning. It was, in their words, coercing the state with a gun to its head.
So how does the scale of the threat to UC compare to that ACA precedent?
The parallel is very strong. As we said, UC relies on over $17 billion annually. 52% of its research is federally funded. The legal challenge argues that the threat to cut funding that accounts for more than half of research and nearly 1/3 of the operating budget leaves the state with no real option but to acquiesce.
It's a gun to the head.
It is coercion on a massive institutional scale, making it analogous to, or potentially even stronger than, the threat faced by states in the Medicaid case. The federal government is weaponizing existential financial pressure to regulate areas of university policy that the state government traditionally controls.
We also have the argument that the executive branch usurped Congress's power. This leads us to the separation of powers challenge, which includes the claim that the $1.2 billion demand is just flat out illegal, the ultra vires argument.
That's correct. The argument asserts that the executive branch acted beyond its legal authority, or ultra vires. Congress holds the exclusive spending clause power. The executive branch can't just unilaterally enact fines or penalties that Congress never authorized.
And Congress never authorized a $1 billion fine for this.
Not even close. The demand for a $1.2 billion payment is illegal because Title VI, VII, and IX, the civil rights statutes being enforced, do not authorize the imposition of monetary penalties or fines. They only authorize the ultimate proportional remedy of terminating federal assistance.
Which itself has all those procedural hoops they allegedly skipped.
Right. So by demanding a massive financial penalty, the administration is accused of essentially rewriting the law, acting as both the enforcement agency and the legislature, and thus violating the separation of powers.
Okay, and finally, the legal challenge targets the procedural integrity of the entire task force policy under the Administrative Procedure Act, the APA. What specific APA violations are being alleged here?
So the entire unwritten enforcement initiative is challenged as violating the APA because it constitutes final agency action that was taken without following proper rules or reasoned decision-making. First, the agencies failed entirely to consider the significant reliance interests of the public.
The cancer research.
The cancer research and hundreds of other projects. They abruptly halted ongoing multi-year scientific research projects that the public had relied on. The termination letters claimed these interests were considered, but the lawsuit argues that statement was baseless, failing the APA requirement for a reasoned justification.
And the specific justifications offered for the grant terminations are alleged to be arbitrary and capricious, suggesting the civil rights pretext was just a flimsy cover.
Exactly. This is the third point of the APA violation. The actions were arbitrary and capricious, meaning they lacked a rational connection between the facts presented and the enormous sanction imposed.
What's an example of that?
In one instance, the agency's alleged race discrimination at UCLA based solely on the university's consideration of applicants' zip codes, family income, and school profiles during admissions review.
But universities do that all the time to get context.
It's a routine practice used to assess socioeconomic disadvantage and provide holistic context. Yet the agencies use this as the sole basis to conclude illegal race-based preferences, a conclusion the lawsuit says is unsupported by factual evidence.
And the justification for the Title IX demands was perhaps even more tenuous.
It was. The claim that UCLA's policies regarding transgender individuals created an unsafe environment for women was used to justify the complete suspension of all UCLA funding. But the evidence cited for this alleged safety risk was arbitrary.
What was it?
It relied on nothing more than the mere existence of a publicly available UCLA bathroom map.
A map.
A map. The agencies offered no reasoned support or actual evidence of safety risks to connect the existence of a bathroom map to the necessity of suspending over $500 million in scientific funding. This disconnect demonstrates a pretextual justification, one designed to impose ideological demands, not ensure safety, making the action arbitrary and illegal under the APA. So this deep dive really lays bare a systemic, coordinated campaign. You have this task force policy that utilized civil rights enforcement mechanisms, specifically Title VI and NIAX investigations, as a pretext.
A cover story.
A cover story for imposing a specific, wide-ranging ideological agenda on major U.S. universities. And this campaign runs in parallel with that other high-stakes lawsuit challenging state sovereignty regarding resident tuition, placing the entire California Dream Act in jeopardy.
Ultimately, what is truly at stake here extends far beyond academic politics or university budgets. For you, the listener, what is at risk is the immediate public benefit and fundamental constitutional rights. We have billions of dollars in critical scientific, medical, and technological research hanging in the balance projects that stand to improve human health, safety, and technological innovation.
And at the same time,
the economic mobility of low-income and first-generation college students, the very people supported by the UC and CSU systems, is under direct threat from the tuition lawsuit.
the core takeaway of this confrontation is whether the executive branch can successfully weaponize federal funds and enforcement authority by bypassing statutorily mandated procedures and demanding unauthorized fines to dictate institutional policy and suppress viewpoints it disfavors. The entire legal fight hinges on preventing academic independence, which is a crucial engine of American innovation and free thought, from being permanently transformed into a political bargaining chip in the face of financial ruin.